Welcome to another episode of Conduct Detrimental. Dan Lust on the mic. We are joined by Jason Morrin and Justin Nader. What's up, boys?
How are we doing today?
Not much. What's going on, guys?
Justin, your debut on the podcast. You ready for this?
Yeah, I'm excited.
So we have kind of a loaded episode. We're going to talk a little bit of basketball. We're going to talk issues on the fallout of the Kyrie Irving saga continues. We'll talk a little bit of Ime Udoka. We'll talk Brittney Griner. We're going to talk about this fascinating Mitchell Miller situation in the NHL. And then at the end, we're going to have on Dan Greene and Ryan Whelpley to talk college sports, the House case, the Jonson case, new NIL legislation. So, yeah, we're going to get in the weeds here, which are better for worse. You want to know all the stories going on in sports law. You want to be informed. This is probably a good episode for us. Let's start with a topic that I think everyone is familiar with. We've covered it now twice in the last 2 weeks. This one will be very quick. Let's start in the world of the NBA, and then we will move over to Brittney Griner and the WNBA. I guess to put a pin on all of our Kyrie Irving discussions, right? Kyrie, I imagine, will at some point return back to the Nets. Will it be immediately after his 5-game suspension? That remains to be seen. So we had Mike Vorkunov on from The Athletic, and he essentially said, right, when Woj and Shams report on something that it's close to happening, it's pretty much a done deal. So by all indications, Ime Udoka was going to be the coach of the Nets. The Nets hiring Ime Udoka in the middle of the Kyrie Irving saga, I don't know, it's the equivalent of like legitimately pouring gasoline on the fire. Somebody got into, Joe Tsai's head, and they have gone a completely different direction. So Justin, who is the man that is now taking over the Nets job here?
Yeah, exactly as you said. The Brooklyn Nets announced today that they are hiring Jacque Vaughn as their head coach. Vaughn has been serving as the interim head coach since the firing of Steve Nash following, the disappointing start of the Brooklyn Nets. And I think also some infighting within the team. Kevin Durant earlier, even before the season started, called for the firing of Nash or he would leave. So it wasn't a surprise that Nash was out, but the surprise was the hiring of Jacque Vaughn. And this follows a very tumultuous time for the Brooklyn Nets, as there was the Kyrie saga with everything that they had to deal on that side of things. And I think it came to the point that the Nets realized they needed to at least not start another fire. They're not completely putting out the fire on the Nets, but they are not starting another one, and decided to upgrade Jacque Vaughn to the full head coach status.
Yeah, I would just add quick. You mentioned that they kind of started to put more on the fire, but then halted. But why start? Like, what is going on in Brooklyn right now? I mean, you have all of these awful scenarios that you're trying to solve. They're trying to win a championship. I get it. And Udoka's probably a great coach. He had success in Boston, but you can't do that. And the fact that they stopped halfway through, it's just they need some kind of stabilizing force just for PR sakes and just to get back to normalcy and be out of the headlines. So that kind of shocked me. And the fact that they went to Vaughn is ultimately the right move.
Why did they stop halfway through? I mean, this is controversial, but I do think that Kyrie Irving cost Ime Udoka the job for better or for worse. We went on the show last week and we were like, either the Celtics overreacted or the Nets have a really high tolerance for, controversial individuals in their locker room. So maybe it's a little bit of both, right? Maybe the Celtics overreacted. I have some people that have some good sourcing into Nets camp and basketball circles. And I heard through the grapevines that it would have been a very messy situation for the Celtics players if Ime Udoka was hired by the Nets. That would not have looked good in Celtic circles. Like, hey, we're an NBA team, and how are they allowed to have him, and we're not allowed to have him? I think Ime Udoka, for those that don't know, was on the Nets staff within the past 2 years. So there's some familiarity there. Maybe the Nets trusted it. But, yeah, it would be a really crazy story if Ime Udoka was there, and it just doesn't make any sense. Or it wouldn't have made sense. But, we'll see. Again, we were talking about this being kind of unprecedented, like somebody on suspension being hired by another team within the league. We're not going to have it. So it sounded really odd, and maybe not that shocking. It doesn't end up happening. Okay, so we wanted to hit that one quick. Obviously, we've been talking about Kyrie a lot. The other update, Kyrie met with Adam Silver. Dan joked on the last episode, like, how hasn't Kyrie done all 6 of these deliverables yet? Like, how hasn't he done them? How hasn't he spoken out and denounced the movie and done this and done X and Y and Z? We're now like 48 hours after when Dan and I recorded. And as far as I know, Kyrie hasn't done any of them other than meet with Adam Silver. So, obviously Kyrie issued an apology late. I'm sure it took him a lot of mental effort to issue that apology since he really didn't want to. Would it shock me if Kyrie was dragging his feet with respect to these additional deliverables and, speaking out against anti-Semitism and all that? I don't know. Kyrie is as Dan Wallach said, I think it was a good word. he loves contrarianism. And I'm not so sure that Kyrie is so quickly going to be checking off these boxes, or else they would have been done already, right? I don't know what the delay is. Jason, Justin, your thoughts on where we're at in mid Kyrie suspension?
Yeah, I think that the Nets are just at a point now where they just want their player back. They don't want the drama. They don't want any of the stories that have been happening surrounding their franchise. They want their admittedly very, very great point guard to come back and to be able to produce for the team again. And so I think this hiring of the coach is that first step. They believe and they hope that Kyrie will go through all of the steps of his plan to be able to come back from the suspension that the team placed on him. And again, this meeting with Adam Silver was probably that first step of communicating to Kyrie how serious this is, and that if he doesn't do this, this suspension will last for much longer. And the Nets are hoping to avoid that at all costs.
Yeah, it's a really tough scenario for the franchise. I mean, like, there's kind of this tugging forces between like maintaining and improving the value of your franchise and also just straight up winning. And I think right now, like, keeping Kyrie versus maybe trying to get value for him on the market, which is going to be diminished. Obviously, they're kind of competing right now. Ultimately, the 5 or 6 point ultimatum is not something Kyrie is going to be a willing participant in, knowing the kind of person he is.
I agree. The apology was a lot, and I'm sure Kyrie's like, okay, I apologize. I guess we're good now. And then everyone's like, no, now you have to go through more of it. But okay, we'll put a pin in the Kyrie talk, where I guess for our remainder stuff are really kind of pure legal issues. And we wanted to talk, obviously, some pure sports as we get into the rest of the episode. Obviously we're going to put our legal hats on. So let's stick within basketball for this. I've been following the Brittney Griner situation, as close as probably one could. We are right around the 250-day mark for her, period of captivity in Russia through all of this. And for those that don't know, obviously there was trace amounts of CBD oil and found within her luggage in a trip over there. She was playing professionally over there. Why was she playing professionally there and not the WNBA? Because WNBA doesn't pay that much money, and Russia paid a lot of money. So, I guess that explains why she's there. Why she's still there is maybe a more difficult question. So for, I believe, the first 8 months of her period of imprisonment, captivity, whatever you want to call it, she was in a kind of a private, like, Moscow cell. And she had a lot of this reporting is done by TJ Quinn over at ESPN, who's done a fantastic job. But, she had someone in her cell that spoke English, and, she wasn't really, I don't want to say, it's obviously terrible to be behind bars, but by no means was it at a point of like heavy manual labor. And all of a sudden, like in the middle of the night, that has seemingly changed. So Justin, you want to fill us in on where we're at now in the Brittney Griner saga? It's kind of a big turn. I think everyone expected her to be home, and now obviously the tides have turned.
Yeah, today reports came out that Brittney Griner is being moved to a Russian penal colony. And this is a move that was expected following the appeal that was denied, I believe, around October 25th. However, this was unexpected in the sense that it happened sooner than even her attorney was expecting. The attorney expressed that it takes a while, usually following the denial of appeal, to figure out where they're going to send the prisoner and which colony and how they're going to go about it. And I'm sure a bunch of other administrative stuff they have to go through. However, this one seemed a little quicker. And what is now being reported is that no one knows where she's going. Her lawyer is unsure where she's going. Her family doesn't know. Her agent doesn't know. Nobody has any word on where Brittney Griner is going or where she is currently, because of her being in the middle of being transported to that Russian penal colony. So I'm sure that word will come out exactly where she is, but it will take some time as we got to figure out where she's going to be located.
Again, we'll give TJ Quinn the credit. And again, another great podcast. If you aren't listening to it, the ESPN Daily podcast is fantastic. If you want more details, obviously head over there. But, people that have gone to these facilities are doing manual labor. They're, in theory, digging ditches, they're breaking rocks. So, and I guess the scary part, just as you mentioned, like, we don't know exactly where she is. We can't get to a point where maybe her lawyers can visit her as easily and under her normal terms. But yeah, maybe I'm guilty of this as well. Like, I've always kind of said, okay, it's just a matter of when Brittney Griner gets brought back to our country, not a matter of like if it happens, but like when the United States ends up ponying up and engaging in some type of trade-off of some sense. But what I'm understanding with the negotiations so far, that Russia likes the turmoil this is creating, and there was maybe a kind of a thought that this could get done before the midterm elections, that maybe Biden would want to do that to try to curry some favor and help the Democrats out, domestically. But, the deal didn't get done. And I think Putin, at least from the reporting that's being done, might be happy with the turmoil it's creating, here. So I'd rather have turmoil in the United States than do them a favor and give over Brittney Griner. So I keep seeing the narrative, which I'm sure you guys are seeing, like, if this was LeBron James, would he be back already? Or if this was Tom Brady, would he be back? And, I think it's safe to say, I don't know, I can't negotiate a deal for Brittney Griner. Like, what makes you think you can negotiate a deal for someone that has a higher following? And it's not to say that someone's life is more important than someone else's, but, just kind of objective. More people in our country know who LeBron James is or Tom Brady is than know who Brittney Griner is. So I don't think it's a given that LeBron James would be brought back home or Tom Brady. I think it would be even more complicated. But yeah, I mean, it's, what is it, Justin? It's an 8-year prison sentence?
Yes, I believe so. I think the sentence we have so far, again, a lot of what is being reported and a lot of, the narratives that we're hearing is that this is more political than it is actually criminal. It's one of those things that I don't know if it'll last that long. I think there will be a point where Russia and the United States come together and talk about having a release. But again, we don't know when that's going to occur or when that is going to result in any sort of fruitful conclusion.
Yeah. So, I mean, it's tragic that it hasn't happened yet. And I mean, there's certainly been days where, Free Britney has been trending, and it's obviously now Free Brittney Griner. The Britney Spears stuff is kind of wrapped out, but I don't know what more can be done other than applying more pressure. You got to feel for Brittney Griner, who's now trapped. I don't know if she's trapped in a cell. It's manual labor, and we don't really know exactly the nature of her sentence. So it's kind of scary, but obviously we'll keep tabs in it. And, if there is an update, you'll hear it from us. Let's close with the three of us here. The Mitchell Miller stuff. Jason, you had a couple tweets on this. I find the story to be pretty interesting, but you're the hockey fan here. Can you give us some background on this fascinating saga? I mean, I don't quite think I've ever heard of something like this happening, but go ahead. Where are we at?
The Boston Bruins have taken the hockey world by absolute storm over the last week. And you'd think it's because they're having the franchise's best start in history. They're 11-2 right now, and that is not controlling talks. The media is focusing on a young player named Mitchell Miller. And this has been a very contentious topic for a couple of years now, but the Bruins brought this back to light. So to rewind, Mitchell Miller was a 4th-round draft pick of the Arizona Coyotes back in 2020. But soon after that selection by the Coyotes, an article came out from the Arizona Republic that basically detailed this really heinous history of bullying, which included a conviction in juvenile court for how extreme the bullying was that Mitchell Miller had conducted, with one fellow classmate as his victim. So the Coyotes claimed that at the time they made the pick, they knew of the bullying at a surface level, and they planned to use this pick as a time to rehabilitate Miller. And, they thought that it wasn't as egregious as what the article detailed. So with that, they revoked his draft rights. They revoked the pick, and he became a free agent. So, no team would go near him. And now here we are 2 years later, and Miller is still playing. He's in a junior league. He's actually playing in your state of Nebraska.
It's not my state, but go ahead.
And he's doing really well. So the Bruins thought it would be a grand old idea, led by President Cam Neely and General Manager Don Sweeney, who somehow are always in the news for the wrong reasons nowadays. They gave Miller a contract. They signed Mitchell Miller after he's been a free agent for 2 years since the Coyotes renounced their rights to him. This is a team that's really devoid of any talent in the pipeline in terms of young prospects. So that kind of speaks to why they would do this. And Miller's agent claims that other teams were also competing to sign it. So I don't know about the veracity of that, but he went on a hockey podcast recently and said that. So with that, the hockey world was taken by storm. The Bruins signed Mitchell Miller, and the backlash that the Bruins organization received for the signing has just been enormous. I mean, every single person in the hockey world, community, media has been really just using all their power to say this was the wrong move. How could we afford an opportunity to Miller, who most importantly never apologized to the victim? That was something that was in the article we knew about, the Bruins organization knew about. The kid never apologized to the victim. So the Bruins signed him. And Justin, why don't you tell our listeners what happened since then, with the Bruins now trying to reverse their decision and what they claim has changed since the signing.
Yeah, the Bruins have sort of backtracked. They've decided, with all the controversy that's come out, as soon as the signing was announced, there was a large outcry from the public. And this public was not just, hockey fans. There were players from the Bruins organization that spoke out against the signing. Specifically, one of the biggest names in hockey, Patrice Bergeron, even came out with a direct statement saying that he didn't want this person on the team. And that's sort of how everyone at Bruins have kind of felt. And the Bruins themselves have even backtracked saying that when they signed him, they believed that this whole bowling incident was an isolated incident, that it was just one time, which is hard to believe considering that the article, which was published, like you mentioned, in Arizona in 2020, outlined years of bowling, not just the isolated incident that led to the initial conviction. So the Bruins are definitely at this point just trying to backtrack and get out of it as much as they can.
Can I ask you guys, do you know this pitcher? I would be super impressed if either of you have heard of him. Luke Heimlich? No. So, I mean, this issue, it's not that this issue is so novel, like a player doing something in their past. This guy, Luke Heimlich, was a pitcher for Oregon State, was named the Collegiate Baseball Pitcher of the Year. He went 11-1, 16 starts in the Pac-12 conference, 11-1, get this, with a 0.76 ERA and 16 starts. Guy is named literally the pitcher of the year, goes undrafted. So why does he go undrafted? Because he had this crazy, molestation thing in his past, pled guilty. There's some commonalities. The difference being, right, I'm not aware of Luke Heimlich playing well in his post-career, right? I think I'm looking at some stuff in 2019 and 2020. As a 23-year-old, he's now at playing in the Mexican League, 4.5 ERA, 4.6 ERA. So I guess, the difference with the story with Mitchell Miller is like here, he didn't maybe he got cut from his team or he got drafted, but obviously, they cut bait with him. Then he ends up playing really well after that. So, I mean, what do the Bruins think? Like the Bruins thought just like everyone forget about, like, hey, been in a league for a couple of years, no big deal at this point, right? That seems to be the only difference in the story. Like, in truth, the truth is everyone deserves a second chance. I think if the Bruins had handled this the right way and said, you know what, we are aware of the allegations. We've spoke with him. He's apologized privately. I don't know. Maybe now we're kind of getting into Kyrie terms. Jason, he still hasn't apologized as of today, as of the time of this recording.
Yeah. So as part of the juvenile proceedings, he was actually required to apologize. So it was a court-issued apology. It was,
What's
complete
wrong with
BS.
A court-issued apology? You got to do a
because
separate
he never personally went to the victim and said what I did was wrong and let's move on. He continued to do the same actions after that court-issued apology. It was
I
just
didn't realize
enforced.
that. He's alleged to have continued the actions after the incident occurred.
Yeah, this went on for years and years.
Interesting. Oh, that's a very big difference. So he has
and by the way,
a catch-all apology.
He issued a statement to the 31 teams that could draft him, and then they didn't realize he never even apologized to the victim. And by the way, when we talk about bullying, we're not saying that this is just a little name calling and shoves in a locker. This was like really heinous stuff. This was a black student with mental disabilities, and Miller would use just disgusting racial slurs, and it got to the point where the worst thing was, those push pop lollipops. He rubbed one of those in a urinal and then forced the kid to eat it. Just, heinous stuff like that. And then Mitchell releases a statement recently where he says, this has been totally blown out of proportion. I already apologized through the court or whatever it may be. And he said, me and the victim are friends. We're friends. We've moved on past it.
That's not smart.
And then the victim comes out yesterday with a statement to Akeem Alou and the Hockey Alliance. And he says, we're not friends. He blatantly said, we are not friends. This is complete just absurdity that he would say that. The apology was not real. It was not genuine. And he put him through torture for years. So he said, we are not friends. Don't listen to a word he says. And he should not be playing hockey. So you speak to second chances, but it's like he had his third, fourth, and fifth chance already. I think he never appropriately took it.
Truthfully, I don't really have a problem with the court-issued apology. Was he supposed to drive to his house and do one of those shows like the Meet Your Bully in real life? Like, some things it's harder to do, but in this world, right, if he makes a statement that says like, we are friends, he can certainly issue a public statement apologizing in the same type of energy. Yeah. But now we're getting back to Kyrie levels. Like, I don't understand, like for Kyrie, maybe Kyrie's brand in some way, shape or form is standing up to popular opinion and being the contrarian of like, that's what he wants to do. He doesn't want to apologize. I don't get it. Sometimes like, maybe the apology would have just got him back on the right track. But now, Jason, this is the part, obviously, where we found some interesting stuff. From the NHL level, the NHLPA level, you're getting the sense that the NHLPA is going to stand by this guy and try to protect the contract?
Yeah, I feel like they will. So this is the legal meat and potatoes. So, they signed Mitchell Miller to an entry-level contract. So that's a 3-year deal, and he's getting like, over $800,000 per year, or it might be $900,000. So it's no small sum. And this is a 3-year deal. So The Bruins, through Cam Neely, announced that, Justin spoke to it, that new information came to light. So they wanted to part ways with Miller. But you can't just say you part ways. This is basic contract law. To part ways with someone, there has to be a mechanism to do so. So either a contract buyout, not available. You can only do that after the season. You can do that after one season accrues. They can't buy him out right now. You can put him on waivers, sure, but it's been 2-3 days. So if you put someone on waivers, there has to be a cause. It has to be, even the playing level fell off or there's just not a spot right now. But this is a clear PR move. So the NHLPA has a great avenue to say, hey, this is a breach of contract, that you can't just part ways with him right now, that there's no real cause to do so, that nothing has changed. There's also an argument that I saw someone pose that, isn't this a violation of what's commonly in contracts called a morals clause? That if you, the same reason how Adidas got out of the contracts with Kanye, and it's happened many times before, where if you act in a way that is totally antithetical to what the company stands for, who you are contracting with, they can, sever ties because you have breached the morals clause. Here, we can't say that this is applicable because the conduct that Miller has done here occurred before the signing of the contract. This is two parties who signed in good faith, and the Bruins knew everything. They can't claim to have been ignorant to the facts and that this is now a recent morals clause issue. Everything occurred pre-signing. So, I could see a lawsuit stemming from all this if the Bruins do go forward with refusing to pay him or, otherwise parting ways.
Yeah, I mean, it's a simple point. It's basic due diligence, right? What changed? And I think if we're trimming through all the fat and trying to figure out a translation here, it's the Bruins just said, well, I guess people have probably forgotten about it by now. Like, yep, like the kid that he was bullying is probably not going to say anything anymore. Like, yep, we're probably pretty good. And people do, I just want to be clear, people do deserve second chances in life. Just because you did one thing, even if it's really bad, the correct level of repentance that you feel bad about it. Like, it's not a one strike world that we live in. But it seems that corners were cut here. The people in Mitchell Miller's camp didn't do the right things, dared this student, the kid that he was bullying, to respond. And the guy continues every time they give him an invitation to speak out against him, he does it. So it's a bizarre story. But let's see, Jason, it's $900K a year for 3 years?
Yeah, he's got a 3-year salary. The average annual value is $950,000. The cap hit to the Bruins is just over $860,000. So, obviously no small sum, and it's a 3-year deal.
Okay. I guess we'll continue to keep tabs on that one. Okay. Jason, Justin, fantastic job. I will take it from here. Okay. So let's just be very brief. Those guys obviously did a fantastic job breaking down a couple of big stories in basketball and hockey. We're going to take the remainder of the episode talking about college sports. So I kind of warned you guys at the top of the episode, we are going to be going into the weeds of college sports, like the weeds, like the law review weeds. If you might want to write an article on these topics, we're going to get that deep in this. So why? Obviously, we try to keep this to big daily events in sports, but we're trying with this particular space, college sports, to look ahead, to help our athletes, our coaches, our agents that listen to this podcast prepare ahead and try to advise their clients accordingly. And if you're trying to get into the space, and I can tweet about it as many times, but the space is still very messy until the NCAA wants to create these bright line rules in terms of what schools are doing wrong and what they're going to be punished for and what athletes are going to be punished for. It's going to require a lot of lawyers to get involved and agents and have really smart conversations around the space to try to figure out, based on precedent, based on what's happening here, what's happening there, what is or should be allowed, and helping to lobby and create those efforts on the legislative front, be it the state or the federal level. So here's what we're going to do. Ryan is going to provide a tremendous breakdown of two very big cases. That's the Jonson versus NCAA case and the House versus NCAA case. Let's stick with Jonson first. We've talked about on the show, about a year and a half, that the next battle to be fought is going to be this unionization issue. And what happens when college athletes can unionize? They can go on strike and they can get locked out, right? It's a completely different world. I've talked about it for a year and a half. I don't know how quickly it's going to happen. Jonson case is obviously in its early phases, but that's a case that's in theory going to open the floodgates for unionization if and when it does happen. So Ryan's going to have a lot of updates on that front. If you haven't been following the case at all, Ryan does a really good job at breaking down the underlying facts of the case and then kind of where we're at and, some complex legal terms, but we always try to explain it. And then the other case that Ryan is going to help us break down, the House versus NCAA case. That's a case that really is going to help define NIL. Like, quote, NIL means name, image, and likeness. Now, what we have said, should get kids paid at this point in NIL is just third-party marketing and maybe boosters, right? The schools are still not paying the athletes. This lawsuit right now, House versus NCAA, is designed to try to give student athletes a piece of the television money, ticket revenue, merchandise, stuff that maybe the school would like to keep for themselves, which certainly they'd like to keep for themselves. But that's certainly the battle that's fought there. Again, Ryan's going to explain where that case has been and where it is going, and maybe some recent updates on that front. And then last but not least, and Dan's going to be with us the whole time, Dan Greene. We're going to talk about some updates in the NIL front, specifically Pennsylvania, maybe some interesting nuances within that law. But yeah, we really do want to look ahead and kind of help prepare you guys for this next phase of NIL. What do we do on the show? Mainly, we just kind of react to updates in the news. We kind of tell you, we keep an eye on certain stories. We tell you where they're going. But for college sports, we're really going to try to forecast where they are going and tell you the updates that maybe you're not going to hear about on ESPN or The Athletic, but really the weeds that only lawyers can get into. So yeah, it's certainly our pleasure to break it down. And without further ado, let us kick it over to Dan Greene of Newman and Lichstein and Ryan Whelpley of Morse Law. We do this about every couple of weeks, maybe every couple of months at this point. We have Dan Greene from Newman and Lichstein and Ryan Whelpley on from Morse Law to talk about most recent updates in the college sports arena. So we have the House case, we have the Jonson case, we have some state NIL, we have potentially some high school NIL coming out. But I think it's about time for an update. So for our listeners, obviously we covered the new NCAA regulations that came out, but there's obviously a lot of moving parts in the college front. So I thought the best place to start, as we've been alluding, that there could be some litigation that potentially rewarded athletes for television revenue. That's the House case. And then maybe even at one point called athletes employees. So Ryan, do you want to kick us off with, maybe a little bit of a refresher on what's going on in this House versus NCAA case and kind of the most recent update in the case?
Yeah, sure. Thanks, Dan. It's great to be back on the pod. And just to kind of give an update for the House versus NCAA case, again, the plaintiffs are several college athletes that are arguing that the NCAA and its member schools, as well as the Power Five conferences, have illegally conspired through amateurism rules to deny economic opportunities to players. And the case focuses on missed opportunities for college athletes to profit off their NIL since the change last July. And it also seeks injunctive relief for the current NIL policies. They're arguing that they limit the full scope of an athlete's publicity rights. So that's kind of sets the basis for the plaintiff's argument, is that it's an antitrust violation and that they're seeking missed opportunities from NIL. And the NIL revenue broadly includes broadcast revenue that's been distributed to NCAA schools and conferences. And so that the plaintiffs are looking for damages and clawing back that revenue as well.
Just to be clear, Ryan, they're looking for previous revenue. That's maybe not necessarily something that the schools have accounted for, the television partners have accounted for, previous broadcast rights?
Yeah, so the kind of the NIL revenue, broadly construed to include the broadcast revenue that was, based on the publicity of the athletes, appearing in games for the last several years, and to receive a portion of the revenue from that for missed opportunities that they didn't have because of the restrictions on NIL previously, which could be, you were talking, multi-billion dollars of, revenue that's already been distributed to conferences and member schools. And so part of their argument is for damages is some of that broadcast revenue.
Ryan, wouldn't this also include the college video games that weren't made? I think I recall there was an argument that, based on the rules of the NCAA and its talks with EA Sports, that the part of the argument here is that there was lost revenue from these players' right of publicity for not being in these games and for these games not being made.
Yeah, that's exactly right, Dan. That's one of the missed opportunities, is the video games that were not made because of these rules. As we recall, EA Sports had a series of games, college basketball, college football years ago that were discontinued. And that is part of the lost revenue that they're claiming as well, is that they've missed opportunities to appear in these video games and they could have profited off their NIL.
So Ryan, I guess moving forward, I don't want to derail you here, but it's a big case. It's a big case I don't think is really getting that much attention. And obviously with the amount of money that's involved, multiple billions that's already been paid out, you're talking about clawing back that money. And obviously moving forward, when you're talking about, guys, what was the reported Big Ten deal? What was it, $7 billion? What was the number?
I forget the number on the top of my head, but it was more than I make in a year.
It was a number. I'm going to say it was in the billions, but we can confirm that. But you're talking about that large of money moving forward. Obviously, athletes should be paying attention. So, we've been kind of following this case. It involved some high profile players. Sedona Prince, House was I think it was a Stanford swimmer, if memory serves. What, Ryan? What's the latest here? Like, are we anywhere close to trial? Like, where do we stand in the process?
Yeah, so the plaintiffs recently filed for class certification. They aim to represent, thousands of, current and former college athletes who've, been denied the NIL revenue. And right now, the plaintiffs have proposed 4 different classes. The first is an injunctive relief class, which would consist of all D1 athletes who, competed from, I think, when they filed the complaint in 2020 to the date of the judgment in the case, which is scheduled, I think, for 2024, and obviously could face additional years of appeal. So that injunctive release class could really stretch out. And the purpose of that, again, is just to compel the NCAA to change its rules. The plaintiffs are arguing that the rules are still limiting the scope of what they can really benefit from the publicity right. So that's the first class. And the other 3 classes are damage classes, and meaning that they're seeking monetary compensation. And the main one is the football and men's basketball class, which again would consist of D1 men's basketball and football players since, time period till when they certify the class action. And again, that's the revenue really producing sports. And the other 2 damage classes would be women's basketball classes, and then an additional sports class would be like the catch-all for the other non-basketball, non-football D1 players and the non-revenue sports. So that's what they're seeking right now. And, as we know, class certification is not an automatic process, and they'll have to put forth arguments, various requirements under, federal rules of civil procedure. And one thing to note with that is it's before Judge Wilkin, who's the same trial judge who presided over Bannon and Alston. So that gives any indication how, she might rule, presiding over these cases and maybe certifying that class. So that's where it stands currently, is with the class certification and working through that process. So it's still ways away from, heading towards trial or anything like that.
Yeah, Ryan makes a great point about, if class certification were to be granted, I believe that's over 6,000 athletes that would be included there. And that would basically mean that the NCAA, its member schools, which would claw back like billions of dollars and redistribute that money to current and to former athletes as well, which would be ginormous. And I don't even know how that would be allocated for. And also to harp off what Ryan said, like this is the same Judge Wilkin from the Alston case. It's funny that we talk about this House case. House is the NIL case. I see a lot of people talk about the Alston case and basically refer to that being, that was the NIL case because, from the fallout from the NCAA right after that. But, as we know, like the Alston case is important here. One, because it's also an antitrust case. Same judge. And what the Alston case basically said is that the NCAA is subject to ordinary antitrust scrutiny, that the former precedent of, this whole myth around amateurism and the importance of amateurism is not as strong as it used to be. I think the NCAA has held on to some of the statements from Justice Stevens in the University of Oklahoma case from 1984. Like as Kavanaugh said in his concurrence, is like the NCAA is no longer above the law. I think that was the exact quote. And there's questions about whether the NCAA's remaining compensation rules can still pass muster in antitrust analysis, which is what is happening here in House. And, if the same principles apply from Alston heading into what's happening in House, that Alston case was a 9-0 decision. So, there is a decent possibility, assuming that this case goes forward, that there's a good chance of good outcome for the plaintiffs here. But there's still that whole looming issue with the NCAA basically petitioning Congress to pass a bill for antitrust immunity. I believe that was even included in one of the proposed quote unquote NIL bills recently. I think that might have been Senator Wicker's bill that mentioned that. So we'll see how things play out there.
I mean, we could talk about the federal bills that are still kind of percolating at the end. But, Ryan, you mentioned that these different classes of revenue generating athletes versus non-revenue generating. I've always thought there could be a problem when we got to the unionization question when it comes to which sports could unionize, right? Maybe the college baseball team could unionize. Maybe for some schools, maybe that's a revenue generating sport. I don't think so by and large, but let's say you had, I'll pick like the golf team, right? And the golf team by and large is not going to be a revenue generating sport at nearly all schools. And let's say, right, they're pretty happy with the way the NIL is working. Let's say the house money hasn't come in yet. It's the normal NIL that we're dealing with right now. And the football team at that golf school, they want to unionize. They're going to unionize, assuming they have that right, which we'll talk about in Jonson in a minute. They're going to unionize separate and distinct from the golf team, separate and distinct from the wrestling team. So we've talked about this issue a lot in our show, that if someone's going to unionize, it's not going to be college athletes as a whole. It's going to be specific pockets of sports, men's sports versus women's sports. Because if the football players want to unionize and they want to get a piece of the pie, why would they include potentially these other sports? So, Ryan, I think of our two, obviously the House case, Dan, you mentioned, is like, it is the NIL case. You can say, put NIL in quotes because it's defining what NIL is, what it should be. The current definition of NIL, I'm sure schools are, kind of happy for it because it doesn't include, and I confirm this number, $7 billion, the Big Ten's contract, $7 billion, basically $1 billion a year through 2030. But that money is carved out, right? So this has always been, they can call it third party money that's coming in or booster money that's coming in, whatever they want. It's never been the school's money. So that's where things get complicated when we talk about Jonson. So, Ryan, you want to give us just like you beautifully did with House, you want to give us a brief background on Jonson? We could talk a little bit about that and obviously figure out the most recent updates.
Yeah, sure. So Jonson case, I believe it started in 2019. Trey Jonson is a former Villanova football player, and several other Division I college athletes filed a claim under the Fair Labor Standards Act against a group of colleges and universities, some of which they attended and some of which they didn't, that, part of the Northeast, as well as the NCAA, claiming that athletes should be recognized as school employees who should be paid for the time they spend related to their athletic activities, and that the NCAA is a joint employer alongside the school that the athletes compete for. They argued essentially again that they're employees, and the argument in support of that position was that, look, these Division I schools require athletes to participate in numerous athletically related activities. They have control over, when they attend meetings or participate in practices, schedule competitions. They control suspension, dismissal. Bylaws of the NCAA require them to participate in certain activities such as fundraising, community service. So the idea is that these member schools exercise a great deal of control over the athletes, and that the revenue generated from the schools that the athletes play for should be, distributed to them based on the time that they spend, engaged in activities. They should be paid for participating in these activities, similar to what a work study student would be getting paid for working on campus. There's no difference between a work study student working at the concession stand at a game and getting paid while the athlete is playing in the game and not getting paid for their time. So that's kind of the argument there for the plaintiff. For the NCAA, the schools, they sought to dismiss the case, filed a motion to dismiss, and they had three real arguments in the case. One, college athletes are amateurs. Two, the Department of Labor has determined that college athletes are not employees for purposes of the Fair Labor Standards Act. And three, that athletes fail to qualify as employees based on kind of the economic realities of the relationship between, college athlete and a school. And the district court rejected that motion to dismiss, and they kind of rejected all three of those arguments. Dan Greene mentioned this with amateurism, with the Oklahoma case from back in the 80s and the dicta from it. As far as the argument that NCAA's longstanding policy of not paying athletes is because they're amateurs, they cited the Kavanaugh opinion, saying that's a circular argument. You're saying you decline to pay them because the defining feature of college sports is they're amateurs, and you don't pay them because they're amateurs. It's just circular and unpersuasive, as they said, is the reasoning. So they kind of struck that argument, following the Alston case. So that kind of set the precedent, for that. And the Department of Labor, their second argument, they said that, college athletes are not employees, purposes of the Fair Labor Standards Act, based on, a handbook from the Department of Labor in part, which says participation in extracurricular activities does not result in employee and employer relationship between the school and the student. And they kind of argued that, if you're a student participating in like an extracurricular club at school, you don't have an expectation of there really being an employer-employee relationship.
Is that one of the factors? There's a handful of factors that come into play when determining if there's an employment relationship here under the Fair Labor Standards Act. I think was the beneficiary test. Is that it?
Yeah, so that goes to the economic realities and comes in part with this argument too. That's exactly right. They did kind of a multi-factor test where they balanced different factors, and one of them is that college athletics are not conducted for the benefit of students as opposed to extracurricular groups. Like a student-run group is conducted for the benefit of students. Like education, it's related to the education program if you're in the drama club or if you're in the music club. Whereas college athletics is for the monetary benefit of the NCAA and its universities, really. It's not really designed to enhance the academic program of a student athlete. And that was kind of one of the factors they looked at and kind of analyzed too in the context of this Department of Labor argument, that the benefit really isn't going to the student athlete, it's going to the universities and then making money. So those were kind of the three arguments that were laid out and rejected by the court, the motion to dismiss stage.
So where are we now? We at on appeal? Is that where we sit?
Yeah, so there's an interlocutory appeal. with the Third Circuit right now, where they've agreed to hear the question of whether, Division I college athletes can be employees of their schools by virtue of participating in college athletics. And that's where it stands right now. And I believe that the 3 panel of judges is going to hear a hearing in December. That's what it's scheduled for. And then they might invite people, the attorneys, to deliver oral arguments, but they could also cancel that and they could do written briefs instead of, the oral arguments. But we're still ways away from an actual, trial or decision or anything like that. Right now, it's just kind of at the interlocutory appeal stage, is determining, whether they can be employees by virtue of their just participation in college athletics.
I guess we want to keep tabs on them because we want to make sure our athletes are aware of these things pending around the corner. But it seems like, if anything, House might be a little bit closer. Interlocutory appeal is for lack of better terms, going to hold up the matter while the case is pending, at least to some extent. Okay, Ryan, I think that's helpful on the litigation front. And then the other side of this, that again, sports law comes in all shapes and sizes. We're talking about these 2 court cases, obviously still are continuing to have legislative updates on the NIL end. So, Dan, I know you had a tweet that picked up a lot of traction on the Pennsylvania front. Is that the most recent legislative update?
Yeah, most recent legislative update where a bill was enacted that basically took Pennsylvania's original NIL law, which was one of the first to be effective. I believe it was enacted June 30th, 2021, became effective July 1st, 2021, right after. But included in that original bill was that schools couldn't arrange third-party compensation for its athletes. And in this updated bill, it removes that language, essentially on par with some of the other states that have removed similar language. I believe, was it Tennessee, Louisiana, I believe so. And then you also have states like Alabama that repealed the law altogether for pretty much the same reason, and South Carolina suspending its law for the same reason as well. So it's interesting to see like a state in the Northeast do that. They have some big schools that will probably be rewarded for that. Penn State being one, Pitt being another. So yeah, that's the latest on the legislative front. I don't really expect any really new NIL bills to be coming, because there really isn't any point right now, unless you want to legislate that schools are required to provide certain education on NIL for its athletes, which is actually something. Sticking with Pennsylvania, it was a city, I believe it was a city ordinance or bill, I forget the specific name for it, in Philadelphia, that was adding requirements that high school athletes in Philadelphia that receive certain education benefits. I believe there's a cutoff on, house, home income. I think it was 150K was the cutoff. It was just introduced, I believe, last week. So it'll be interesting to see how that works and see if other big cities similar to Philadelphia also implement certain city laws, ordinances, regulations, or anything like that.
Yeah, I mean, we'll keep an eye on it, Dan. I know you also reported a couple weeks back that Washington maybe was a state that people had not realized had also legalized NIL. But to your point, if you have states like Alabama repealing their NIL law, and I'm not sure necessarily if we're going to see this race to legislation. But I think we could end it with this kind of final topic. We've talked about for about a year and a half the issues of having different states having various advantages. And I was talking offline with someone that helped put together the Pennsylvania law. And they explained, that law had certain nuances to get an advantage based upon what their neighboring states had in their NIL laws. So there's nothing wrong with it, right? That one state wants to make it more advantageous to their athletes, right? That's in a sense, it's not necessarily capitalism, but you want to have some incentive to make this to make it attractive. But at this point, we still have this kind of fragmented landscape of state laws. The federal bills, guys, open this, Ryan, Dan, whoever wants to take it. Are we any closer? I think I had you guys on the podcast maybe in late September. Like, are we any closer to a federal bill? It's been over a year, and I keep hearing that it was close. It's not close. It's close. Are we any closer today?
As far as I know, as far as I can see, we are not any closer. However, we just had election day come and go. So maybe those issues might be picked up now that, more important election related issues have been addressed. So there could be some movement there, but even if there is, I don't expect anything to become, super forefront or pending anytime soon.
I agree there, Dan. I think too, I haven't looked at the latest results, but it depends on, kind of how Congress shakes out too, whether it swings to one side or the other. Democrats are looking for a more expansive bill that includes more than just NIL, that has player safety, health related things in it as well, whereas Republicans are looking for more limited in scope. focusing more just on NIL. So I think it depends on how it shakes up to, following the midterm elections and see, who's in control of, Congress. I think that's one thing to keep in mind too, that could, help decide whether a bill would be forthcoming or not.
I like how you're both like, oh, it could change, but probably not. And we also have no idea because it's NIL and this whole landscape is nonsensical. I mean, you would hope a federal bill would have come at this point, mainly because you had people like Mark Emmer, George Kliavkov again, and Greg Sankey in the SEC asking for it, but it just hasn't been a priority. So Dan, to your point, right now that the midterm elections are over, the three of us are, I think I can say we're not political people. So I would assume that sports should be higher on the totem pole, but it's not. And it was at one point when, our college coaches, I think, were petitioning for it, like Alabama and those schools, when they wanted the NIL bill, it happened. And at a federal level, maybe at this point, it's just not a priority. So guys, Dan, Ryan, anything else to add on the NIL college sports front? We certainly covered a lot of ground, some complex, high-level stuff. Anything else that we have not yet hit?
Nothing really new. I mean, as we discussed with these cases here, these big federal cases, that amateurism is on trial here. And you might be thinking there's been all of these NCAA cases, previously with O'Bannon, and then, they had the whole Northwestern football team unionizing. And, these cases are different for different reasons, especially the Jonson case. I should note that it's different from the Northwestern case, which that relied on the National Labor Relations Act, which is a different act that's at issue in the Jonson case. And the National Labor Relations Act refers to the right of employees to unionize. And this case in Jonson would not automatically allow athletes to unionize and would not mean athletes are paid what the market says they're worth. So this case of Jonson, it concerns hourly wages around minimum wage, just like, as Ryan mentioned, other student jobs on campus. Just to show that it's different issues right now, it's kind of a different avenue that's being taken here. I believe that there has been other federal cases against the NCAA challenging its rules under the FLSA. But as we've noted, and especially as noted as the Alston case, times have changed. Times have changed since the Oklahoma case. And I believe I think it was in the Berger versus NCAA, one of the judges even said, even though they ruled in favor of the NCAA, they said if there was different plaintiffs in that case, whether it's Division I men's basketball or FBS, or revenue sports, there might have been a different resolution there. Because in that case, I believe the plaintiffs were like track and field athletes who sought minimum wage under the FLSA. So I think that might even leave some of the door open to, the economic realities of what these major athletes bring to the table. It's even more apparent what they do bring than it was in the past.
Thank you, Dan. Ryan, anything else that we missed?
The only thing I would add with the Jonson case, and Dan mentioned this too when he pointed to Berger, is that it could set up, a circuit split if, Jonson rules in favor of the athlete and the 7th and 9th, the Court of Appeals have already ruled that athletes can't, be employees under the Fair Labor Standards Act. Could set up circuit split and could be kicked up to the Supreme Court, and they could be the ones deciding the issue, which would be interesting. So that's just something to keep in mind too, as well.
Okay. Well, Ryan and Dan, excellent job as always. I guess we'll continue to keep tabs on this, and we'll see. We certainly had the NCAA, their new guidance recently. I think it continued to leave a lot to be desired, but see what this next level is. But yeah, Ryan, Dan, fantastic job. And I'm sure we'll have you guys back on together very soon.
Sounds good. Thanks, Dan.
Thanks, Dan.
So again, that was Dan Greene and Ryan Whelpley. You can find their information in the show notes. So fantastic job by both of them. That was a very in the weeds conversation. We hope you guys appreciate that stuff. Again, I listen, I've talked about this a couple of times. I listen to a ton of podcasts. A lot of podcasts can tell you what's going on with Kyrie. A lot of stuff, podcasts can tell you what's going on with Brittney Griner. Very few do. We actually are probably one of the few shows that covers the Brittney Griner stuff. But we want to be a show that covers sports law for sports fans and for lawyers that can have a very intelligent conversation about the weeds of the law. And obviously, guys, we're not charging anything for this podcast. So you're basically getting a free consultation from some really smart lawyers who normally charge decently high hourly fees, but coming to you free here, obviously, to get the word out. So if you ever have any questions, anything in the college sports space, you're happy to reach out to me, or you're happy to reach out to my friends at Orr, Horgan, and Flengy. They are the official sponsor of the college sports segments on this podcast. Tom Horgan and Connor Orr were on our podcast basically about a week ago at this point, talking about the new NCAA regulations. So between our conversation with them, which you should go back to and check out in the archives if you have not, and the conversation with Dan Greene and Ryan today, and it's pretty much the whole college landscape. There's obviously going to be new nuanced NIL deals that come out, but you guys now understand the legal framework that's going on in the three big pillars of college sports: the litigation, the NIL, and the NCAA regulations. Masterclass, team, masterclass. We do it each and every week. We talk about sports betting. We talked about it on Monday in the Monday episode with the California sports betting episode. And then we also give you some sports betting picks sponsored by our sponsor, our sports betting guys, Bettor Edge. So, Conlan, listen, I hit you up and I'm like, when can you give your pick? And you're like, later tonight. And then, Conlan, you pop on the Zoom, and you go, you haven't decided your pick yet. Are you winging these things? Are you winging your way to 6-1-1? Is that what you're doing?
Even if I was winging it, I don't think you want to come at the person who is winging it for free cash. I don't think that's the card you want to play, Lust. Listen, I know you do your job. Let me sit back. Let the champ deliver, all right? So stop worrying about whether I'm winging it or not. I'm a well-oiled machine up here delivering winners. So let's get right into it.
Hold on. No, just give it a second, Conlan. So, Conlan, listen, you're Mr. 6-1-1 in sports betting. What's your record in fantasy football?
I spend so much time.
No. That's right. This is a closed question.
Time. I don't even know. I don't care. I
Conlan,
gave up after I drafted two of the Packers running backs on the same team.
All is fair in love in fantasy sports. But listen, you're here for your picks. You're not here for your fantasy sports. 6-1-1. We joke. 6-1-1 is incredibly impressive. And I know the Bettor Edge guys are very impressed. Bettor Edge, again, social betting. So Conlan's picks are going to be from the Bettor Edge site. The reason that Conlan can give some picks that maybe people are like, hey, that's not the line. That line seems off, because it is social betting site. So someone that thinks that they know better than you, they could put up a line that maybe is a point, 2 points off, maybe even 3 points off. They can juice the line up, but it is an open market. So Bettor Edge, use our promo code CONDUCT. You get free $20 for signing up, and then go to town on the rest. But Conlan, go ahead. What's your pick, buddy?
All right. So last week we went down west, and Geno Smith led the Seattle Seahawks, the division-leading Seahawks, against Kyler and the Cards, beating them outright. This week we go to the Music City. I love country music. We're going to land in Nashville. The Tennessee Titans playing host to Bronco Nation. Let's ride. And the Denver Broncos, Russell Wilson, the biggest cornball in the football today. Listen, the Titans are favored -2. Give me them right there. Listen, the Denver Broncos' season has been over since this bozo started doing his warm-ups on Monday Night Football against the Seahawks. It's been an absolute embarrassment. Nathaniel Hackett, it's a whole joke. Let's see. I like Mike Vrabel. I think they're better run. They're looking to capture a division title once again. So the Titans -2 seems easy here.
Okay, so I love the pick, Conlan. We always bring this back to sports. We can't just do pure sports betting. This is public. People can Google this. I had a lawsuit. I can now somewhat speak about it. My firm had a lawsuit last year, or actually it was a couple months ago, against the Denver Broncos. So, we went to war with the Broncos. We ended up settling the case. Stuff is now public. But for a period of time, I was not very happy with the Denver Broncos. So you know what I did, Conlan? Did I tell you the story?
No.
I put a large bet on the Denver Broncos under for the season. And that under at the time, the line was set at 10.5. You know what that updated line is? 7. I'm going to win this one clean. 10.5. So yes, I am not a fan of the Denver Broncos, which I don't know. I don't usually hate teams.
So you guys settled, but you guys couldn't get the Broncos Nation Let's Ride, that you couldn't axe that out of the settlement? Like that couldn't have been something you could be like,
oh, no. I mean, that is listen, maybe they would have hired us. I would have told them that was a terrible idea. And also to play the B-roll of that in the background. I mean, I don't know whose idea that was, but from Hackett to Wilson, all up and down that roster, it's a very flawed roster. I don't know what they're doing with the three-headed running back over there. I dropped Latavius Murray. There is no one on this entire roster that has fantasy value.
No, not a single one.
Yeah, but in any event, I like the pick. In one of my fantasy leagues, I have the Titans defense. I'm all in on betting against the Broncos in all way, shape, or form. And it's been a very, very profitable endeavor. So, Conlan, I'm riding with you. Conlan Farrell.
Let's go, baby.
Let's ride.
Yeah, Conlan, that's it.
we will put this episode in the books. Excellent job. A big thank you to Jason Morrin, Justin Mader, Ryan Whelpley, Dan Greene, Conlan Farrell, and of course, Dan Wallach. And for all of us here, we will see you next time on another episode of Kind of Detrimental.